Financing your small business is no small feat. It can be a long and tricky process, but this also opens up the potential for small businesses to fall into financial hardship and default on your loans. I'm Kalilah Reynolds, and it's time for another episode of Money Moves JA, brought to you in partnership with EXIM Bank's Business Advisory Service, giving you the tools to grow your business. Joining me now is attorney at law at DunnCox, Topaz Johnson, who'll tell us what to do if you default. Hi, Topaz. How are you doing?
Hi, Kalilah. I'm doing well. How are you doing?
I'm great. Thank you for joining me. I know, this third wave of COVID is really tough, huh?
It is. But thankfully, we've been coping so far, and it's good to see you.
Yes, and thankfully we're still able to do this interview virtually, so I'm happy to have you.
Thank you.
So today we are talking about loans, and more specifically, what happens when you run into problem with your loans, especially now during this pandemic time. This has been an issue that has faced lots of small businesses. Something happens and you're unable to service your loan. From a legal standpoint, what's the next step, Topaz?
Well, perhaps we can start with what a loan is, just to make sure that we're on the same page. And a loan, we can say, is an outright transfer of money from a lender to a borrower, subject to a contractual obligation for the borrower to make the periodic payments of interest throughout the term of the loan and to pay the capital at the end of the loan period. So this should allow us to understand what types of loans a small business can get, and therefore what the obligations will be under the different types of loans that exist. I don't know if you want us to go there at this point.
Yes, let's go through that. So what are the types of loans that small businesses would typically be eligible for?
We can put it into three categories. We can say that we have term loans, revolving loans, and demand facilities. Term loans are made for a period of time, and that's what we call the term. And the term is defined by the contract. So it's very important to understand that loans are governed by contracts between the borrower and the lenders. In the term loan, early repayment as demanded by the lender or offered by the borrower is permissible only under the contractual provisions. So term loans are most appropriately used for longer term periods. Revolving facilities are those that allow the borrower to repay either in part or the entire loan and require the lender to advance the funds again. And demand facilities we usually think of in terms of overdraft being the most popular example. They don't have fixed times for repayment, and a loan can be determined or demanded by a lender without notice.
So those are good things to know when you're going into it. You definitely want to be aware of the different types of loans that are out there and which one is most suitable for your needs. When it comes to interest rates as well, you have fixed and you have variable interest rates. Is there a preference? Is anyone better, Topaz?
Again, it depends on the business, because a fixed term interest rate may be better for certain types of purposes, while a variable interest rate may be better. And it also depends on economic conditions, because it depends on your expectations as to what interest rates will be over a period of time.
So you have to pay attention to the market, pay attention to what's going on.
Absolutely.
All right. So what constitutes a default on a loan now? You just miss a payment and that's considered a default?
Very interesting. I hate to give you a long answer to your question, but for a default, we have to understand that we're not just talking about payments. A default can be defined as a breach of any covenant of the loan agreement. And it can even be inclusive of circumstances that may adversely affect the feasibility of the loan from the lender's perspective. So a borrower breaches or defaults on a loan contract when, without having a lawful excuse to do so, it fails or refuses to perform the obligations under the contract, or it performs them imperfectly. And this can be any of those covenants. So when I talk about any of these covenants, we could spend all morning talking about what types of covenants there could be, but we could put them into 4 pretty neat categories for standard loan contracts. We can talk about the condition of the borrower being one of the elements of the loan agreement. When we talk about condition, is the company registered? Is it in good standing with the company's office? Is it meeting its financial ratios? A second category is the feasibility of the loan. Has there been an adverse change in the circumstances which will negatively impact the borrower so that it becomes difficult to meet its financial obligations? A third category, that's where we talk about things like the negative pledge and pari passu clause, and those really just have to deal with how one lender is assessed against another. And lastly, I'll mention the performance, which is where the payments come in. So if any of the requirements under these covenants is breached, it would be a default, not just payments. However, I'll note that not all defaults have the same consequences. The most critical types of defaults are usually called the events of default. So
Events.
Yes, events of default. That's a popular term in loan agreements. So a missed payment will usually be an event of default, and usually the first event of default in that list. But let me quickly add that sometimes exceptions can be negotiated by the borrower, such as for a late payment, which occurs merely because there's a technical or administrative error, and not because they can't make the payment.
So if you do miss a payment, it doesn't automatically ensue that it is a default and the lender takes action against you. What should you do?
Well, it depends on what is said in the contract, because yes, it can be one missed payment that constitutes an event of default. But again, the loan agreement may have been negotiated so that it adds some flexibility, and the number of days after which the non-payment is not made may be increased and may mean that there is not an event of default. But if it is that you have, in fact, exhausted all that is allowable in the loan contract, we can say that there are perhaps 2 main things that you should do. Firstly, it would seem best to have a candid conversation with the lender to explain the circumstances and negotiate a proposal for the restructuring of the debt. And the restructuring of the debt is what will allow, for instance, for a longer period to pay, being just one of the terms that can be adjusted. But second, I can't not mention, without getting into the technical details, that if a borrower is facing insolvency or is in fact insolvent, it can make a formal proposal under Jamaica's Insolvency Act, and doing so could allow it to benefit from some of the provisions, including perhaps a temporary stay of proceedings that would otherwise be available to the creditors, and importantly, getting technical assistance from a licensed insolvency practitioner called a trustee in formulating the proposal to present to the creditors. But I'll acknowledge quickly that the Insolvency Act is a fairly complex piece of legislation, but it may be worthwhile for a borrower in this situation to seek some advice to see whether it should take advantage of the provisions and how it does so, because it can be a very useful piece of legislation for borrowers.
I see. I see. So, what are some of the consequences if one does end up defaulting on a loan, unfortunately?
Well, the loan contract may stipulate that if an event of default occurs, the lender can do one of three things. It can cancel the commitment if there are further advances to be made under that contract. It can declare that funds advanced are immediately repayable with interest, or it can declare that the funds are repayable on demand. But if the loan is a secured loan, the lender also has rights to take steps to enforce the security. Generally, however, the lender does have to send a notice of intention to enforce the security to the borrower.
And by that you mean if you use some property or a motor vehicle or some asset to secure the loan, they would seize that asset.
Well, that's one of the options, but it really depends on the type of security that the borrower has given and this type of security interest in law that the lender has. So let's use some examples. If the lender has a debenture that is charging all the assets of the borrower, that's a popular security instrument, it can appoint a receiver of those assets. The powers that that receiver has would be set out in the debenture instrument and in some relevant legislation. Of course, the objective of the receiver would be to use the assets to provide money to repay the loan and the interest and other costs that are incurred in the process. So that's a debenture. Under a mortgage, one enforcement option a lender has is the power of sale. And this allows the lender to contract directly with a purchaser of the property and sell that property to the purchaser. So it really is dependent on the type of security that we're talking about.
So finally, what can businesses do to ensure that they don't end up in this position in the first place?
No, that's a great question. I can give you 3 tips. Firstly, I would say it starts with the negotiation of the original loan contract with the lender. Ensure that the terms of the contract are suitable for the business and the purpose of the loan. There are some clauses in typical loan agreements that can be made at least a little more flexible through negotiation. It usually helps to have experienced professionals involved in the negotiation process. Now, I just say that because what I found is that some business owners don't realize that lenders don't have a general obligation to them to advise them on the viability of the lending transaction from the borrower's perspective. Secondly, the borrower should remain conscious of and monitor what is expected of it under the loan agreement. And thirdly, if the performance of the obligations under the loan contract are in jeopardy, seek to have early candid discussions with the lender with a view to negotiating a restructuring before an event of default is committed.
Well, thank you so much for these great tips, Topaz. Much appreciated.
It was my pleasure.
It's good to go into a loan with your eyes wide open, knowing exactly what the possibilities are.
Agreed.
All the best to you.
Thank you.
Here's a recap of some of Topaz's key points. When you take out a loan, ensure that the terms of the contract are suitable for the business and the purpose of the loan. Remain conscious of and monitor what is expected under the loan agreement. And if the performance of the obligations under the loan contract are in jeopardy, seek to have early, candid discussions with the lender with a view to negotiate restructuring before an event of default is committed. Well, that's it for this episode of Money Moves JA, brought to you in partnership with EXIM Bank's Business Advisory Service, giving you the tools to grow your business. Visit their website at eximbankja.com and visit my website, KalilahReynolds.com, for a summary of this episode. You can click the link in the description box below. I'm Kalilah Reynolds. Until next time.
Let's get this money.